Hello and welcome. If you're tuning in, you're likely deep into your UPSC preparation journey.
hmm
Staying informed is crucial, but it's more than just headlines. It's about understanding the deeper trends.
Absolutely, like the one we're tackling today.
Exactly. We're doing a deep dive into something quite concerning, highlighted recently by the Chief Justice of India himself, Sanjeev Khanna. It's this growing trend of criminalizing civil disputes in India.
And it's definitely something UPSC aspirants need to get their heads around. It touches on law, governance, the judicial system.
Both mains and prelims relevance here, for sure.
Definitely. The CJI's strong words really signal its importance.
Our main source for this discussion is an insightful report from Bar and Bench. So our mission today, understand why this is happening, what it means, and what the courts are suggesting.
Basically giving you that analytical edge for your exams.
Let's start with the CJI's comments. What sparked them? What did he actually say?
Well, the context was, interestingly, a check bounce case. Pretty standard stuff, usually. Yeah. But in this instance, it wasn't just about the bounce check. They'd also tacked on much more serious criminal charges.
Like what?
Things like breach of trust, intimidation, even criminal conspiracy. Serious allegations layered onto what often starts as a financial disagreement.
Wow, okay, so a major escalation.
Exactly. And that's what drew the CJI's criticism. He wasn't just commenting on one case, you see.
He saw a pattern.
Precisely. He expressed strong disapproval of this tendency, warning it could undermine the very distinction between civil and criminal law.
That sounds fundamental.
It is. He even warned that if it goes unchecked, it could lead towards a breakdown of the rule of law itself. A stark warning.
Okay, that's serious. So for anyone maybe new to this specific concept, let's define it clearly. What exactly is the criminalization of a civil dispute?
At its heart, it's taking a private dispute, something that belongs in civil court, like a contract disagreement, a property issue, owing money.
Right, disputes between people or companies about rights and obligations.
Yes, and trying to force it into the criminal justice system by framing it as a crime, like fraud or cheating or breach of trust.
Which then allows for things like police involvement, FIRs, potential arrest.
Exactly. Much heavier consequences than typical civil remedies like compensation.
Can you give a few more concrete examples? What kind of civil cases are being twisted like this, according to the Bar and Bench report?
Sure. Beyond the check bounce scenario we mentioned, it's happening with money recovery suits, simple contractual disagreements.
Like a supplier not delivering goods?
Yeah, that sort of thing. Also, inheritance disputes, property partitions, commercial deals gone sour. The common thread is trying to paint one party as having criminal intent.
Let's use that relatable example you mentioned earlier. Mr. A lends money to Mr. B. B doesn't repay. How does that become criminal?
Okay, so the civil route is clear. A sues B for the debt in civil court.
Standard procedure.
But the criminalization happens if A claims B never intended to repay, that the loan itself was obtained dishonestly, deceitfully right from the beginning.
Ah, alleging dishonest intent from the outset.
Exactly. By doing that, A tries to make it a case of cheating under the Indian Penal Code Section 420 currently, or Section 318 in the upcoming Bharatiya Nyaya Sanhita.
And that changes everything, doesn't it? Suddenly, Mr. B could face arrest.
Precisely. It shifts from you owe me money to you are a criminal. It's a massive leap.
That really clarifies the mechanism. Now, the big question, why is this happening more? What's driving people to take civil matters down this criminal route?
Well, there seem to be a few key factors at play. A major one is, frankly, the perception of the civil justice system.
That's too slow.
Painfully slow, often. Cumbersome, ineffective sometimes in delivering timely relief. People get frustrated.
I can imagine. And the stats back that up, right? The Bar and Bench report probably touches on the national judicial data grid figures.
It does. We're talking over a crore. There's 10 million pending civil cases in district courts. And something like 68%, more than two-thirds, are over a year old.
That kind of delay understandably makes people desperate for faster results.
It does. And there's a belief, right or wrong, that filing a criminal case creates more immediate pressure. The fear of arrest, the police involvement, it might force a quicker settlement.
So using the threat of criminal action as leverage.
That seems to be a big part of it. It's seen as a shortcut, bypassing the long wait times of civil courts.
The report also mentioned other, maybe more systemic issues, like influence or police incentives.
Yes, that's another layer. Sometimes influential parties might lean on the police to register an FIR in what's really a civil matter.
Using connections.
potentially. Or there could be incentives, perhaps misplaced ones, for police to register FIRs to, show activity, or simply to apply pressure as requested. It basically weaponizes the FIR process.
But wait, isn't the criminal system also massively overloaded?
Oh, absolutely. That's the irony. While people might think it's a shortcut, they're pouring these inappropriate cases into an already overwhelmed criminal justice system.
What are the numbers there?
Out of about 4.5 crore total pending cases in India, around 3.44 crore are criminal. So adding civil disputes disguised as crimes just makes that backlog worse.
It's really counterproductive then.
Completely. It strains resources, delays genuine criminal cases, and it's fundamentally unjust to the person wrongly accused.
It's good to know the judiciary, especially the Supreme Court, is aware and pushing back. You mentioned they've addressed this before.
Yes, consistently over the years. Bar and Bench highlighted a key case from 2000, G. Sagar Suri versus State of UP.
What was the core message there?
The court explicitly warned against using criminal proceedings as a shortcut for civil remedies. They stressed that criminal courts need to be extremely cautious before issuing starting the formal criminal case if it looks like a civil dispute in disguise.
Because the consequences are so severe for the individual.
Exactly. Liberty is at stake. And this isn't ancient history either. There was a very recent observation cited.
From May 2024.
That's right. In C. Subaya at Kadambur Jayaraj versus the Superintendent of Police. The court flatly stated it had no doubt that a purely civil dispute was being dressed up with a criminal prosecution involving fraud and breach of trust.
So the message from the top court is clear and consistent. Stop doing this.
Pretty much. They see the pattern and they're calling it out.
Okay, identifying the problem is one thing. What about solutions? What are the courts suggesting to actually curb this misuse?
They've put forward a few ideas. One significant point came up in the Indian Oil Corporation, or as NEPC India Ltd case back in 2006.
What was that?
The idea of accountability. Holding the complainant responsible if they initiate or pursue criminal proceedings, knowing it's really a civil matter.
So consequences for filing a baseless criminal complaint in these situations.
Exactly. The court suggested that if criminal proceedings are found to be unwarranted, the complainant, who should have gone the civil route, could potentially face legal consequences themselves.
That could be a powerful deterrent, surely.
You'd think so. It makes people think twice before trying to misuse the criminal system as leverage.
Makes sense. Any other tools or mechanisms mentioned?
Yes, a very practical one highlighted in the report involves using an existing provision. Section 250 of the Criminal Procedure Code.
Section 250? Remind us.
It deals with compensation for accusation without reasonable cause. Basically, making someone pay damages if they file a frivolous or malicious criminal complaint.
And this will become Section 395 under the new BNSS, the Bharatiya Nagarik Suraksha Sanhita, right? Important for aspirants to track these changes.
Absolutely crucial. The laws are evolving. So Section 250 CRPC or the upcoming Section 395 BNSS.
How do the courts suggest using this more effectively here?
The push is for judges to use this power more frequently and proactively in cases where they smell a rat, basically.
Where it looks like a civil dispute with malice behind the criminal complaint.
Precisely. If there's evidence of malice, frivolousness, or just using the criminal process to harass someone over a civil issue, the judge can order the complainant to pay compensation to the accused.
So it provides some justice for the person wrongly dragged through the criminal process.
And it sends a strong signal. Don't abuse the system this way. It aims to discourage these kinds of tactics.
Right. This has been a really helpful deep dive. Understanding this trend, especially with the CJI weighing in, seems critical for UPSC aspirants.
Absolutely. It connects so many dots. Judicial efficiency, rule of law, access to justice, the practical application of legal codes. It's core syllabus stuff, really.
Grasping the why, the how, and the what next regarding this criminalization of civil disputes is key.
It shows an understanding of the real-world challenges facing the Indian legal system.
So let's leave our listeners, our dedicated future administrators, with a thought to ponder. Given everything we've discussed, the CJI's remarks, the proposed solutions like using Section 250 more often, what long-term impact do you think tackling this trend could have on the overall efficiency and fairness of our justice system? And how might this whole issue evolve with the new criminal codes coming into force?
Those are exactly the kind of analytical questions you need to be thinking about for the UPSC exams. There's no single easy answer.
We really hope this discussion has added value to your preparation. If you found it useful, please do like, subscribe, and maybe drop a comment with any follow-up questions.
Your engagement really helps us focus these deep dives on what matters most to you.
And remember, the information we discussed today was primarily drawn from that excellent report by Bar and Bench.
A great resource for keeping up with legal developments. Definitely worth checking out for more detail.